जय हिंद दोस्तों, फिर से आपका स्वागत है हमारे इस वजीराम एंड रवि प्रीलिम्स क्विक रिवीजन सीरीज में, जो कि 2024 का है पार्ट 1 मई से लेकर दिसंबर 2023 तक का। और आप लोगों को डेट पता ही होगा, 26 मई 2024 प्रीलिम्स का डेट है। तो हम लोग इसे कंटिन्यू कर रहे थे और लोग कंटिन्यू करते करते हम लोगों ने कई सारे टॉपिक्स कर लिए थे और आज यह कंटिन्यू लेक्चर रहेगा। तो अगर आप लोगों ने पहले के लेक्चर्स नहीं देखे हैं तो आप लोग कमेंट बॉक्स में ज़रूर बताएं। और हमने डिस्क्रिप्शन में लिंक दिया हुआ है इसका, तो लिंक पे आप जाके क्लिक करें और पहले का सारे वीडियो लेक्चर्स देखें। तो यह कंटिन्यू सीरीज रहेगा, जैसा कि आप लोग जान रहे हैं। तो बस आपसे ये अनुरोध है कि अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें, क्योंकि आपके सपोर्ट की हमें बहुत आवश्यकता पड़ती है। और इससे जब भी हम कोई नया वीडियो अपलोड करेंगे तो आप तक इसका नोटिफिकेशन बहुत आसानी से पहुंच जाएगा और आप इससे देख सकेंगे। आपसे बस यही है कि इसे ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो करंट अफेयर की तैयारी कर रहे हैं और जिनका करंट अफेयर में थोड़ा प्रॉब्लम आ रहा है, तो उन तक इस वीडियो को जरूर पहुंचा, ताकि वो भी अपने यूपीएससी एग्जाम से पहले अपनी करंट अफेयर की अच्छी खासी तैयारी कर ले। यहाँ से हम लोग आज शुरू हो आज का टॉपिक, गवर्नर्स कैन नॉट कीप बिल पेंडिंग इन्फिनिटी। तो शुरू करते हैं। बस ये अनुरोध है कि अगर आप लोग हमारे चैनल पर नए हैं तो चैनल को सब्सक्राइब करें, कमेंट बॉक्स में जरूर बताएं आपको हमारी यह पहल कैसे लगी और लाइक करना ना भूलें। आइए शुरू करते हैं। गवर्नर कैन नॉट कीप बिल पेंडिंग इनफाइनाइटली। कंटेक्स्ट क्या है? तो द सुप्रीम कोर्ट recently ruled that governors are not empowered to keep a bill pending infinitely without any action whatsoever. The court also stated that governors are entrusted with constitutional power but cannot use them to stop the normal proceeding of lawmaking by state legislature. Governors legislative power क्या है? तो ये देखते हैं। आर्टिकल 200 states that when a bill passed by the state legislature is presented to the governor for their assent, they have four options: grant assent to the bill, या withhold assent to the bill, or return the bill for recommendation, or reserve the bill for consolidation of the president. Is there any time limit within which a bill should be returned? The article states that governor may as soon as possible return bill other than money bills, requesting the House to reconsider it in part or in whole. But if the state legislature send the bill again, with or without any amendment, the governor is bound to give his assent to the bill. The court's judgment states that the expansion as soon as possible conveys a constitutional imperative of expedition. It also states that keeping bill pending for indetermined period is consistent with that expression. What can a governor reserve? When can a governor reserve a bill? The governor can reserve certain bill for the consolidation of precedent if first, against previous ruling of SC or it reduces the power of High Court. Second, against the provision of Constitution opposed to the directive principle of state policy DPSP. Third है against the larger interest of country or the grave national importance. Fourth is deals with the contemporary execution of property under Article 31A of the Constitution. Our next topic is Model Prison Act. The Ministry of Home Affairs MHA announced that it has finalized the preparation of the Model Prisons Act 2023. The act will replace the current 130-year-old law, that is Prison Act 1894. As per the provision of the Constitution, prisons and persons detained therein fall under the state list. Hence, the responsibility of prison management and administration solely rests with the state government, which alone is contempt to make appropriate legislative provision in this regard. The Ministry of Home Affairs has clarified with announcing the 2023 Act that it may serve as a guiding document for the state as that they may benefit for its adaptation in their jurisdiction. Prisons Act 1894 क्या था वो देख लेते हैं। तो it defines prison and demarcates prisoners in three different categories according to the nature of their crime. These categories were criminal prisoners, convicted criminal prisons, and civil prisoners. It deals with provisions for accommodation, food, clothing, bedding session, and the discipline of prisons, including solitary confinement. It also laid down provision for the prisoners' employment, health, and visits. However, the Act has no provisions for reformation or rehabilitation. The Act permitted wiping provided that the number of stripes should not exceed 30, allowed for only male prisons. Our next topic is Official Secretariat Act. Historical evolution क्या है तो OSA was first enacted as the Indian Official Secretariat Act at Act 14th 1889 to muzzle the voice of nationalist publication. It was amended and a more stringent version of the act came into being in 1904 when Lord Curzon was the Viceroy of India. A new vision was notified in 1923 as the Indian Official Secretariat Act, which extended to all the matters of secretary and confidentiality in governance in the country. Next is provisions. Section 3 of the Act talk about the secret information, defines spying, espionage, and states that spying will be punishable for 14 years if the crime has been committed in any office or establishment of the defined forces and for 3 years in another case. Section 5 of the Act talk about the disclosure of secret information and state that disclosures shall be punishable with imprisonment for a term which may extend to 3 years or within fine or with both. Section 6 of the Act talk about unauthorized use of uniform, falsification of report, forgery, personation, and false document. Classification. OSA does not mention any criteria for classifying a document as secret. The Ministry of Home Affairs issues departmental secretary instruction based on which official documents are classified into 5 categories depending on the level of sensitivity of the information. RTI versus OSA. Section 22 of RTI 2005 states that it will have an overriding effect over the laws including the OSA. However, under Section 8 and 9 of the RTI Act, the government can refuse information effectively if the government classifies a document as secret. Under OSA Clause 6, the document can be kept outside the ambit of RTI Act and the government can invoke Section 8 or 9. Section 8 Clause 2 of the RTI Act states that access to information labeled as secret under the OSA can be provided if public interest in disclosure outweighed the harm to the protected interest. Next topic, PC and PNDT Act. The Act provides sex selection before or after conception, regulates prenatal diagnostic technique for detecting genetic abnormalities, metabolic disorder, chronological abnormalities, congenital malfunction, and sex-linked disclosure, and prevent misuse for female foeticide. It was first enacted in 1994 as Parental Diagnostic Technique Act, but after undergoing various amendments, it finally became Preconception and Prenatal Diagnostic Technique Regulation and Prevention of Misuse PCPNDT Act in 2004. ऑब्जेक्टिव क्या था तो रिस्ट्रिक्टिंग प्री बर्थ सेक्स assurance and to save the girl child. Provision. Prenatal diagnostic techniques are not only allowed in registered genetic clinic for detecting fetal abnormalities if the woman is over 35, has experienced multiple miscarriage or has a family history of genetic disease. Written consent is required before an ultrasound, and the person conducting the ultrasound and others are prohibited from revealing the fetus gender. The Act established a central supervisory board too. The central government is advised on policy matters concerning prenatal diagnostic and sex selection technique and against misuse. The Act is reviewed and monitored, and public awareness is created against preconception, sex selection, and fetus sex determination leading to female foeticide. A code of conduct is laid down for genetic counseling center, laboratories, and clinics. The Act also requires a 3-member appropriate authority at the state UT level within 3 months of its implications. Members क्या हैं तो an official of or above the rank of Joint Director of Health and Family Welfare Chairperson, an eminent woman representing women organization, an officer of law department, फंक्शन क्या है इसका? टू ग्रांट, सस्पेंड or cancel registration of a genetic clinic or a lab, to enforce a standard prescribed for genetic clinic and lab, to investigate complaints of branch of the provision of this act and take immediate action, to seek and consider the advice of the advisory committee. Power क्या है? तो summon any power in possession of any information relating to violation of the provision of the act, product of any document or material object, issuing search warrant for any place suspended to be indulging in sex prenatal sex determination. Offense and penalties. Every offense under this act can be recognized non-bailable and non-compoundable. Advertisement related to prenatal sex determination is prohibited and punishable with imprisonment up to 3 years and a fine up to 10,000 rupees. Any registered medical practitioner violating this act can face imprisonment up to 3 years and a fine up to 10,000 rupees. For subsequent convictions, imprisonment and extend to 5 years and a fine up to 50,000 rupee. The medical practitioner registration can be suspended for 5 years for the first offense and permanently for subsequent offenses. Prevention of Corruption Act 1988. This act was aimed at making anti-corruption law more effective by widening their convergence and strengthening their provision. Features क्या है? तो it is an amalgamation of provision of Corruption Act PCN 1947, the Law Amendment Act 1952 and Section 161 to 165A of the Indian Penal Code, which contain tweaks in the original provision. It has shifted the burden of proof from the prosecution as mentioned in the CRPC to accused who is charged with the offence. It mandated the investigation to be made by an officer not below the rank of Deputy Superintendent of Police. It covers act as bribe, misappropriation, obtaining a pecuniary advantage, possessing assets disproportionate to income and the like. 2018 Amendment. The Act was amended in 2018 to bring the PCA in link with United Nations Convention Against Corruption 2005, which was ratified by India in 2011. For this purpose, the amendment provided for attachment and administration of property procured by means of an offence under the PCA and increased the minimum imprisonment term from 6 months to 3 years. Right to Person with Disabilities Act 2016. Disability in India. In India, over 2.2% of the total population endures some form of several mental or psychological disabilities. Conceptually, since the condition of disability is rather transient than static, there is no one universal definition of what comprises a disability or who is considered disabled. In India, the list of criteria that categorizes people as disabled was revamped in 2016 and come into effect with the Right of People with Disability Act. Salient feature of Right of Person with Disability Act 2016. It comes into force to give effect to the United Nations Convention on the Rights of Persons with Disabilities (UNCRPD). The Act has categorized person with disability into three: person with benchmark disability, person with disability, and person with disability having high support needs. The Act increases type of disability from 7 to 21 type, and the central government has the power to add more to the list. These 21 types of disability includes blindness, low vision, leprosy cured person, hearing impairment, deaf and hard of hearing, locomotor disability, dwarfism, intellectual disability, mental illness, etc. The Act has increased the quantum of reservation for people suffering from disability from 3% to 4% in government jobs and from 3 to 5% in higher education institutes. Every children with benchmark disability between the age group of 6 to 18 years shall have the right to free education. A separate national and state fund be created to provide financial support to the person with disabilities. National policy for PWD 2006. The existing national policy for persons with disability was adopted in 2006. Implementing agency क्या है तो Ministry of Social Justice and Empowerment. The policy seeks to recognize the PWDs are valuable human resource for the country and seeks to create an environment that provides them equal opportunity, protection of their rights, and full participation in society. POSH Act. Context: a government committee led by MC Mary Kom had discovered that over half of India's 30 national sports federation lack of intellectual complaint committee internal complaint committee, a legal requirement under the Prevention of Sexual Harassment Act 2013. Genesis of POSH Act in 1997. The Supreme Court acknowledged the lack of law ensuring against sexual harassment in workplace, establishing the Viksha guidelines to fill the statutory gap until a law could be enacted. The court guidelines are based on Article 15 of the Indian Constitution and international conventions, including the General Recommendation of Convention on the Elimination of All Forms of Discrimination Against Women. The POSH Bill, the Women and Child Development Ministry introduced it in 2007 and amended it, which came into effect on December 9, 2013 after being enacted by Parliament. की प्रोविजंस ऑफ पॉश एक्ट क्या है तो देख लेते हैं. डिफाइन सेक्सुअल हरासमेंट. अनवेलकम एक्ट इंक्लूडिंग फिजिकल, वर्बल एंड नॉन वर्बल कंडक्ट सच एज रिक्वेस्ट फ्रॉम सेक्सुअल फेवर, मेकिंग सेक्सुअली कलर्ड रिमार्क एंड शोइंग pornography etc. List down 5 criticism that would continue sexual harassment. This include implied or explicit promises of preferential treatment in employment, threats of detrimental treatment, threats about employment status, interference with work, creating any intimidating or hostile environment, and humiliating treatment like to affect health or safety. Defines an employee. All women employees, whether employed regularly, temporarily, contractually, or an ad hoc or daily wage basis, as apprentice or intern, can seek redressal to sexual harassment in the workplace. Expands the definition of workplace beyond traditional offices to include all kind of organization across sectors, even non-traditional workplace, for example tetracommuting and places visited by employees for work. Applicability क्या है तो this include all public and private establishment in India that engage in commercial, vocational, educational, entertainment, industrial or financial activities, both organized and unorganized sectors and non-governmental organization. इंटरनल कंप्लेंट कमेटी आईसीसी एंड लोकल कमिटीज़ तो वो क्या देख लेते हैं. द लॉ रिक्वायर्स आर एम्प्लॉय विथ मोर देन 10 employers to form an ICC where a formal sexual harassment complaint can be filed by a woman. ICC has powers similar to those of a civil court in respect of summoning and examining any person on oath and requiring the discovery and production of document. Composition of ICC. It is required to consist a minimum of 4 members, at least half of whom should be women. A presiding officer who has to be a woman employed at a senior level at the workplace. 2 members from against employees and who have the experience in social work or have legal knowledge. 1 external member from NGO to preempt any undue pressure from senior level. The MOWCD introduced in 2017 an online platform, CBox, that directs complaint to employer or organizations ICC. Besides, the act mandated every district in the country to create a LC to receive complaint from women working in firm less than 10 employees and from the informal sector including domestic work etc. Role of ICC and LCs. Those two bodies have to conduct inquiries in line with the POSH Act and comply with the principle of natural justice stated in the rules of the Act. There are two ways to resolve the issue by the committee. पहला है through conciliation between the complaint and the respond, which cannot be a final settlement, or committee could initiate any inquiry taking appropriate action based on what it finds. नेक्स्ट टॉपिक इज डिजिटल पर्सन डाटा प्रोटेक्शन एक्ट 2023. बैकग्राउंड इसका क्या है, तो इट इज़ द एसके पुट्टास्वामी वर्सेस यूनियन ऑफ इंडिया केस इन 2017 in Supreme Court upheld privacy as a fundamental right. Following this, the Person's Data Protection (PDP) bill first draft was suggested in 2018 by the Justice Sri Krishna Committee. The committee was revised by the government and was introduced as PDP bill in 2019. Later the bill was withdrawn. तो इसका एप्लीकेबिलिटी क्या है, तो द बिल will apply to the processing of digital personal data within India. It will also apply to the processing of personal data outside India if it is for offering goods or services or profiling individual in India. Consent क्या है, तो personal data can only be proceeded by lawful purposes and consent and a notice must be given detailing the purpose and data collection. Consent can be withdrawn at any time, and for individual under 18, legal guidelines provide consent right and duties of data principal. The data principal has the right to access processing information, request correction and ensure of personal data, and nominate another person to exercise right in case of death or incapacity. Transfer of personal data outside India. The central government will inform countries where a data feudatory can transfer personal data, with this transfer being subject to a specific term and condition. Exemptions क्या है, तो rights of the data principal and obligation of data feudatories except data security will not apply in sacrificed cases. This include prevention and investigation of offense and enforcement of legal rights or claims. The central government may, by notification, exempt certain activities from the application of the bill. This includes processing by government entities in the interest of the security of the state and public order and research, archiving or statistical purposes. Data Protection Board of India. The central government will establish the Data Protection Board of India. Key function of the board includes monitoring complaints and imposing penalties, directing data feudatories to take necessary measures in the event of data breach, and hearing grievances made by affected persons. Penalties क्या है? The schedule to the bill specified penalties for various offences such as up to rupees 200 crore for non-fulfillment of obligations and for child, and 250 crore for failure to take security measures to prevent data breaches. Next is कॉफ़ी पोसा एक्ट 1974. अबाउट, तो ये न्यूज़ में क्यों था? द एक्ट प्रोवाइड द प्रिवेंशन डिटेंशन फॉर द पर्पस ऑफ कंजर्वेशन एंड आर्गुमेंटेशन ऑफ foreign exchange and preventing smuggling activities. It also empowers authorities to confiscate properties and assets acquired through smuggling activities of or foreign exchange violation. Communication क्या था? तो any detention order made by the state government or by an officer of the state government must be forwarded to the central government within 10 days. Detained persons should be communicated the ground for detention within 5 days or within 15 days from the date of detention in exceptional circumstances, with written reason for the delay in communication. Grounds for detention. If a person has been detained on 2 or more grounds, then such order of detention should be made separately on each of such ground. Applicability क्या है? तो this act is applicable to Indian citizen as well as foreigner who are involved in smuggling goods including gold, narcotics or other prohibited item or or who engage in foreign exchange violations. Power of examining the detention order. High Court can examine detention order prior to execution, and a detention order cannot be challenged as per execution stage on ground of delay in execution. No detention order can be held invalid only because ये हो जाएगा तो the detainee is outside the limit of the terrestrial jurisdiction of the government or the office making the order of detention, or that the place of detention or of such person is outside the said limit. Next is Digital India Act 2023. Context क्या है तो the Ministry of Electronics and Information Technology MATI recently announced the Digital India Act 2023. It will replace the 2-decade-old Information Technology Act 2000 और IT Act. की प्रोविजन क्या है तो इट क्रिएट स्पेशलाइज्ड एंड डेडिकेटेड एजुकेटरी मैकेनिज्म फॉर ऑनलाइन सिविल एंड क्रिमिनल ऑफेंस विच is easily accessible delivery time remedies resolve cyber disputes etc. It places a strong emphasis on online safety and trust with a commitment to safeguarding citizens' right in the digital realm while remaining adaptable to shifting market dynamic and international legal principles. It recognizes the growing importance of new age technologies such as artificial intelligence, AI, and blockchain, and provide guidelines for the responsible utilization. It upholds the concept of an open internet, striking a balance between accessibility and necessary regulation to maintain order and protect users. It mandates stringent know your customer KYC requirement for wearable devices accompanied by criminal law sanctions. It contemplates a review of the safe harbor price, which presently shield online platform from liability related to user guaranteed context, including a potential shift in online accountability standard. Next is Forest Rights Act 2006. About the act is considered a milestone because earlier act does not recognize the symbolic relationship of the STs with the forest and their dependence on the forest. Features क्या है? The act recognizes and vests the forest rights and occupation in forest dwelling schedule tribes FDSTs and other traditional forest dwellers OTFDs who have been residing in such forest for generation but whose rights cannot be recorded. It provides a framework for the recording the forest rights so vested and the nature of evidence required for such recognition and vesting in respect of forest land. नोडल एजेंसी क्या है तो मिनिस्ट्री ऑफ द ट्राइबल अफेयर्स. रोल ऑफ ग्राम सभा क्या है तो ग्राम सभा इज द अथॉरिटी टू इनिशिएट द प्रोसेस ऑफ डिटरमाइनिंग द नेचर एंड एक्सटेंट ऑफ इंडिविजुअल और कम्युनिटी फॉरेस्ट राइट्स और बोथ. Rights recognized under the Act. Title rights. It gives FDST and OTFD the right to ownership to land formed by tribals or forest dwellers subject to the maximum of 4 hectares. Also, the ownership is only for land that is actually being cultivated and no new land will be granted. Use right क्या है the rights of the dweller extend to extracting minor forest produce grazing area etc. Relief and development rights to rehabilitate in case of illegal eviction of forested displacement and to basic amenities such as restrictions of forest protection. Forest management rights. It include the right to protect, regenerate or conserve or manage any community forest resources which they have been traditionally protecting and conserving for sustainable use. Our next topic is Kaveri water dispute and other major river water disputes. What Kaveri river? पोनी रिवर इसको एक होते हैं तो इसके बारे में देखते हैं. It is an interstate basin that originates in Tala Kaveri in the Brahmagiri hill of Western Ghats in Karnataka and passes through Tamil Nadu and Pondicherry before draining into the Bay of Bengal. It also known as the Dakshin Ganga, the Ganga of the south, third largest river after Godavari and Krishna in southern India, the largest in the state of Tamil Nadu. ट्रिब्यूटरीज क्या है तो लेफ्ट बैंक ट्रिब्यूटरीज देखते हैं. हरंगी है, हेमावती है, ओरिजिन इन वेस्टर्न घाट ज्वाइन द रिवर कावेरी नियर कृष्णा राजा सागर शिमशा है और अर्कावती है। राइट एंड ट्रिब्यूटरीज में देखते हैं तो लक्ष्मण त्रिकिता है, काबिनी है, ओरिजिनेट इन केरला एंड फ्लो ईस्टवर्ड टू ज्वाइन द कावेरी एंड एट तिरुमुरा कूडल नरासीपुर स्वर्णवती है और होनी होल भवानी है, लोका पावनी है, नयाल है, अमरावती है। डैम्स इस पे कौन कौन से बने हुए हैं तो हरंगी एंड हेमरावती डैम, कृष्ण सागर डैम इन कर्नाटका एंड मिट्टूर डैम इन तमिलनाडु। About the Interstate Water Dispute Act 1956. It was enacted in 1956 amended in 2002 to include Sarikira Commission's recommendation in accordance with the provision under 7th Schedule and Article 262 of the Constitution. 7th Schedule में क्या है तो defines the legislative authority over water resources in entry 17 state and entry 56 union territory. Article 262(1). It states that the Parliament may, by law, provide for the adjudication of dispute or complaints with respect to the use, distribution, and control of water of any interstate river and river valley. Article 262, Clause 2. Neither the Supreme Court nor any other court can exercise its jurisdiction in respect of any such dispute or complaint referred to Clause 1. The Sarkaria Commission mandated a 1-year time frame to set up water dispute tribunal and a 3-year time frame to give a decision. The act empowered the central government to set up an ad hoc tribunal for the adjudication of a dispute between two or more states with respect to interstate river or river valley. The decision of the tribunal is final and binding on the parties of the dispute. Neither the Supreme Court nor any other court has any jurisdiction with respect to any water dispute referred to such tribunal. The Supreme Court has jurisdiction to decide any dispute between states in connection with water supplies if legal rights or interests are concerned. Major interstate river water dispute. गोदावरी तो ये कौन कौन से स्टेट में तो देखते हैं महाराष्ट्र। डिस्प्यूट्स कौन कौन से स्टेट में तो महाराष्ट्र, आंध्र प्रदेश, कर्नाटक, मध्य प्रदेश एंड उड़ीसा एंड स्टार्टेड इन 1969। कृष्णा के लिए महाराष्ट्र, आंध्र प्रदेश एंड कर्नाटका ट्रिब्यूनल 1 फॉर्म हुआ 1969 में और ट्रिब्यूनल 2 हुआ 2004 में। नर्मदा के लिए राजस्थान, मध्य प्रदेश, गुजरात एंड महाराष्ट्र ट्रिब्यूनल फॉर्म हुआ 1969। रवि एंड ब्यास पंजाब, हरियाणा एंड सतलज ट्रिब्यूनल हुआ 1986 में। कावेरी हुआ केरला, कर्नाटका, तमिलनाडु एंड पौंडीचेरी ट्रिब्यूनल हुआ 1990 में। वेंसाधरा हुआ आंध्र प्रदेश और उड़ीसा के बीच 2010 में। महाद्यायी हुआ गोवा, कर्नाटका एंड महाराष्ट्र में 2010। महानदी हुआ छत्तीसगढ़ एंड उड़ीसा 2018। Our next topic is Odisha Riadi's draft of PESA Act 2000 PESA Act's rule. Context is क्या है तो post 27 year of enactment of the Panchayat Extension to Scheduled Area Act 1996, Odisha has finally introduced the draft of Odisha Gram Panchayat Extension and Scheduled Area PESA Rule 2023 about Panchayat Extension to Scheduled Area PESA Act 1996. The PESA Act 1996 was brought in a response to the long-standing demand of the Tribunal Committee in India for greater authority and control over their own affairs. PESA Act was enacted on this 24 December 1996 to enable tribunal self-rule in 5th Schedule Area. An act drew inspiration from the provision of the 73rd and 74th Amendment of the Indian Constitution. PESA Act gives special power to the Gram Sabha in scheduled area, especially for managing natural resource. Major provisions क्या है तो ग्राम सभा. The PESA Act established the Gram Sabha, a forum for the participation of the community in development process. The Gram Sabha is responsible for the identification of development projects, the preparation of development plans, and the implementation of these plans. Village level institution क्या है? The Act provides for establishing village level institution to carry out development activities and provide basic services to the community. These institutions could include the Gram Panchayat, Gram Sabha, and Panchayat Samiti. Power and function. The PESA legislation gave the Gram Sabha and the Gram Panchayat significant power and function in relation to the management of natural resource, the protection of environment, and the regulation of economic activities. consultation according to the act requires that the Gram Sabha can consulted before any development project or activity are undertaken in scheduled area. Funds क्या है? The act allow transferring fund to the Gram Sabha and Gram Panchayat to enable them to perform their function. Next is land. The act provides for the protection of land rights to the tribal communities in scheduled area and require that this consent be obtained before any land is required or transferred. Cultural and social practices. The act protects the cultural and social practices of the tribal community in the scheduled area and prohibits any interference in these practices. Next is unlawful association under UAPA 1967. Context ऐसा क्या? The Ministry of Home Affairs declared the Jammu Kashmir Democratic Freedom Party as an unlawful association under the Unlawful Activity Protection Prevention Act UAPA 1967. Unlawful Activity Prevention Act UAPA. The UAPA was enacted in 1967. Under the Act, offence and cognizable arrest could be made without a warrant. It lays down the definition and rules for designating an organization as an unlawful association. It is if it is engaged in certain type of activities. Unlawful activities is defined as any action taken by any individual or association through an act, words spoken or written, or by sign or visual representation, which is intended to support a claim to bring about the cession of a part of the territory of India or the secession of a part of territory of India from the Union, or which incites any individual or group of individuals to bring about such secession or secessions. It covers activity which declaim, question, disrupt, or are intended to dispute the sovereignty and territorial integrity of India, and which cause or intend to cause disaffection against India. In 2004, the UAPA was amended and terrorist activities were brought within its fold, under which 34 outfits, including the Lashkar-e-Taiba and Jaish-e-Mohammed, was banned. Under the Act, the central government was designated an organization as a terrorist organization if it commit or practice in acts of terrorism, prepares for terrorism, promote terrorism, is otherwise involved in terrorism. The 2019 amendment gave the Home Ministry the power to designate individual as a terrorist. That extended to the whole of India. It also applies to citizens of India who are abroad, persons in service of the Indian government, and person or ships and aircraft registered in India. Penalty क्या है? तो the death or imprisonment of life, and shall also be liable to a fine if such act has resulted in the death of a person. Reforming India's criminal law. The government introduced three bills in Lok Sabha to replace the existing criminal laws in India. These bills are Bharatiya Nyaya Sanhita 2023, replacing the Indian Penal Code IPC 1860. भारतीय नागरिक सुरक्षा संहिता 2023, replacing the Code of Criminal Procedure CRPC 1973, and भारतीय साक्ष्य बिल 2023, replacing the Indian साक्ष्य बिल Indian Evidence Act 1872. की फीचर्स ऑफ भारतीय न्याय संहिता 2023. सडिशन कैसे होगा? तो इट इज द BNS बिल प्रोविजन 150 अंडर दिस चैप्टर pertaining to offense against the state talk about acts endangering sovereignty, unity and integrity of India. टेररिज्म क्या है? तो फॉर द फर्स्ट टाइम वर्ड टेररिज्म हैज़ बीन डिफाइंड अंडर द BSA बिल which was not there under IPC. In the BNS bill, the offense of defamation carries a simple imprisonment of up to 2 years, or with fine, or with both, or with community services. Mob lynching क्या है? तो for the first time capital punishment has been introduced for the offense of mob lynching. Sexual exploitation of women on the pretext of marriage, job promotion, or by concealing identity will be considered a crime. The new bill omits the provision of the offense of adultery. This is the line with the Supreme Court's ruling in 2018 in the case of Joseph Shine versus Union of India judgment. The new bill does not include any punishment for the unnatural sexual offense against men. This is in line with the Supreme Court anonymous reading down of section 377 of IPC. The provision legalizing marital rape has, however, been retained. Speedy legal procedure. According to the proposed bill, a charge sheet has been bill have to be filed within 19 days, and the court can give permission for another 19 days. Probe will have to be completed in 180 days and sent for trial. After trial, judgment will have to be given in 30 days. Key feature of Bharatiya Nagrik Suraksha Sanhita 2023. Greater use of technology. Trials, appeal proceeding, recording of deposition, including those of public servant and public officers, may be held in electronic mode. The statement of the accused too can be recorded through video conferencing. Communication devices में क्या होगा तो on the direction of a court or a police officer, a person is required to produce any document device that is likely to contain digital evidence for the purpose of an inquiry. Use of handcuffs. If police officer may be permitted to use of handcuff where arresting a person if he is in a repeat offender who escaped from custody or has committed an organized crime, terrorist act, offense against the state etc. A specific safeguard. As per the bill, no person can be arrested without prior permission of an officer not below the rank of DSP in case where the offense is punishable with less than 3 years or if the person is above 60 years of age. Mercy petition. After being informed by jail authorities about the disposal of the petition of a convict sentenced to death, he or his legal heir or relative can submit a mercy petition within 30 days to the governor. If rejected, the person can petition the president with 60 days. No appeal against the order of the president shall lie in any court. Section 2. Prosecute. A decision to grant or reject sanction to prosecute a public servant must be reached by the government within 120 days of receiving a request. If the government failed to do so, the sanction will not deemed to have been accorded. No sanction is required in case including sexual offense, trafficking, etc. Arms in possession. With the provision granting power to the DM remain as they are in section 144 of the CRPC, the provision to prohibit carrying arms does not find a mention. Sample without arrest. The bill has provision for the magistrate to order any person to give sample of his signature, handwriting, voice, or finger impression for the purpose of investigation without being arrested. Detention by police. There are provisions for public to detain or remove any person resisting, refusing, or ignoring or disregarding direction given as part of Prevention Act. A trial in absentia. It prescribed in stagnant anti-terror legislation such as Unlawful Activities Prevention Act UAPA, where an alternative criminal law framework applied. In such law, the burden of proof is reversed, with the onus on the accused to prove himself not guilty, rather than the state carrying the duty to prove guilty against the accused. Key feature of Bharatiya Sakshya Bill 2023. According to the bill, electronic evidences in any data created or sentenced by a system or device that can be kept or accused using any method. It establishes prescribed standard for the admissibility of electronic evidence, including authenticity, integrity, and dependability, which can stop digital data from being abused or manipulated. It acknowledged expert opinion as type of evidence that can help establish relevant fact or circumstances for a case, much like medical opinion or handwriting analysis. It presents the presumption of innocence, which states that everyone accused of a crime is thought to be innocent unless and until they are proven guilty beyond a responsible doubt. As a basic tenet of criminal justice system, it lays out specific guidelines for the admissibility of DNA evidence, including permission and chair of custody, which can improve the precision and dependability of biological evidence. नेक्स्ट इज रजिस्ट्रेशन ऑफ बर्थ एंड डेथ अमेंडमेंट एक्ट 2023। तो उसे हम लोग अगले वीडियो लेक्चर में देखेंगे। इस वीडियो लेक्चर को हम लोग यहीं पे समाप्त करते हैं। उम्मीद है कि आपको यह वीडियो लेक्चर पसंद आ रहा होगा, तो कमेंट बॉक्स में जरूर बताएंगे हमें आपको हमारी यह पहल कैसी लग रही है और आप इसमें किससे लाभान्वित हो रहे हैं। वीडियो को लाइक करें, ज़्यादा से ज़्यादा शेयर करें लोगों तक जो इस बार के UPSC एग्जाम देने वाले हैं उन लोगों तक इसे जरूर पहुँचाएँ, ताकि वे भी अपना करंट अफेयर का रिवीजन अच्छे से कर सकें और करंट अफेयर क्वेश्चन में वो सहज महसूस करें। तो मिलता है आपसे अगले वीडियो लेक्चर में, तब तक के लिए जय हिंद, जय भारत।